Hi, we're back. Good morning again. This time we're here for real. Looks like we're ready to start. Sort of hour. Took care of some other things. So let's get to it. We got people in the waiting room. Sorry for the false start at 9. Person in the waiting room doesn't match our first case. It matches our second case. We've got these crammed real closely together. Probably could have spread them out, although I think I'm the one that set these, so there's nobody to blame but me. Miss Weaver, can you hear me?
Yes, I can, sir.
Good morning. This is Judge Middleton. I'm going to ask you if you could turn your camera on.
Do what?
Turn your camera on.
I don't have a camera.
There's a camera here somewhere. Where do you turn it on at?
The little icon that says video, there's a little video camera with a slash through it. Should be down the lower left.
Just touch it.
Yes.
Come in.
Kind of turn the camera on.
Yeah, I've got it.
Oh, okay.
All right. We'll do the best we can. Good morning, Miss Richmond. Oh, there you
Good
go.
morning.
Didn't realize you were here. Thank you.
You're welcome.
It is time for our landlord-tenant docket. It's 9:59. Terry Richmond is here on our first case morning at 10. Melinda Weaver is here on our next case. We'll address that one in just a moment. Let me get my date up here. 29. All right, our first matter, it's 10 a.m. is Terry and Larry Richmond versus Frank Poway. This is a property on 4th Street in Three Rivers. The file is 251394, filed as a demand for non-payment of rent. Seems like we had one of these just a few months ago with this defendant. Ms.
Yeah.
Richmond, what's the status here?
Right now, he owes $945.52 in rent. Court costs of $116.66, with a total of $1,062.18 through July.
That's what I want to know every time. How much are the costs? And nobody does it. Hey, the lawyers don't do it. I know, you lay it right out clearly for me. Now, Mr. Poway was served by attachment. Is he still?
He's still there. He told Lydia he was going to pay and stay. He told Larry he was moving. So I don't know. He's a mess.
All right. Well, somehow today I spread your cases out. I apologize. You got to come back a little later, but
yeah, that's all right.
This case is by attachment, so I can't do a default. So let's look at our time here. I'll try to put your new cases together. How about if we continue to Tuesday, July 29th at 9:30?
Okay.
You mean I have to come back?
No, she's not talking to you.
No.
All right, Miss Richmond, I'll see you a little later.
Yep, 11:10, I believe.
All right, I'll see you then. Thank you.
All right, thank you.
Yeah, but there's also
All right, Miss Weaver, I'll be with you here in just a moment. I was hoping maybe somebody else would show up. So I would have to do the advice of rights twice, but let's go ahead and do it now. Our next case is Washburn Lake versus Melinda Weaver. Washburn Lake is now known as Neighbors
Yeah.
of Washburn. Miss Weaver, you're here on a landlord-tenant case. And as a defendant in a landlord-tenant case, this is they're asking you to pay rent. You have certain rights. Let me tell you about those now. As a defendant in a landlord-tenant proceeding, what have you got? Yes?
You can't do this paperwork.
Tell them to come back at 11 o'clock,
11.
or I'll call him. As a defendant in a landlord-tenant case, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. That's why you're in the conference room rather than bring you right into the courtroom. The legal aid attorney hopefully will be here with us. And she can be available for consultation using the Zoom. So that's why you're there. I'm not afraid to have you in the courtroom, look you in the eye. You have a right to a trial by a jury or by the court. You have a right to have the matter heard here in St. Joseph County where the property is located. If you do wish to have a jury trial, you must tell me at this first hearing and be prepared to pay the $50 jury demand fee. Or file a written demand within 5 days unless the judge waives your fee for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that's what this is. You may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, housing assessment and resource agency, that's Neighborhoods Inc. Or if you're a veteran, you may be eligible for veterans benefits. You do not need a judgment against you to receive this help. A copy of the summons and complaint is sufficient. You've already received that. You may be able to reach an agreement with the landlord by going through mediation or community dispute resolution. If both parties are interested, the court can set that up. You may be able to reach an agreement with the landlord. It means the case would be dismissed, in which case we would accept for filing what's called a conditional order of dismissal. Now, the plaintiff isn't here yet, Ms. Weaver, but I have a question. I don't have a copy of a lease. Do you have a lease?
No,
And it says that this rent is $385 per month. Is it lot only?
yeah, just lot rent. I own the trailer.
No, that they said we can't pay rent since the
All right.
March is here and.
I'm gonna put you in the waiting room. Don't go away. I'm waiting for the lawyer to show up.
Well, now,
All right, we've advised her of her rights. Our next case is at 10:10. Mr. Poway showed up. He called and said he couldn't zoom in. Seemed like he did in the past. So Miss Richmond is set to be here again at 11, and I'll take a crack at Mr. Poway at that point. I don't like doing this by telephone only. If you can't do it, what you should do, what this lady did is actually come into the courthouse. Everybody's forgotten what that was like. They had to take the afternoon off from work. They had to come to the courthouse. All the cases were set at the same time. There were 10 cases. They were all set at 1:15. Everybody would sit here on the wooden bench in the courtroom waiting for their case to be called. Now they're set each for a discrete time by Zoom, which works great if you know how to use Zoom. But as you can see, many people can't. We have 2 Washburn Lake cases. Well, we're not off to a very auspicious start. 1 no-show defendant, 1 show defendant. Here's somebody, which is probably the next case. Cassandra Strasser. Good morning. Are you Cassandra Strasser? Who am I speaking with? This is Judge Middleton at the court in Centerville. As I said, when it works, it's good. When it doesn't, it's all right. Here's somebody on behalf of a plaintiff. Who is on the Samsung phone? I can't identify you. Is it?
My name's Donna College.
All right.
I got on a little too soon. Mine's not until 10:20.
That's fine. Let me give you a name. College, Collige. All right, Miss College, stick around. You might learn something. All right,
Okay.
Nicholas Gordon Sanford of Palitz Law Firm is here right on the tick at 10:10 for our 2 Washburn cases. Mr. Gordon Sanford, we advised her of her rights. And we determined that she has no lease and that this is lot rent only. Payless Law Firm does a lot of landlord tenant work around the state. There's a debate on whether you can even do this. It's filed as a demand for non-payment of rent in a mobile home case with lot only. The only mechanism to do this is the just cause termination of a mobile home tenancy. And so this issue was raised several times, and we spent a long time on it at the all judicial conference in Detroit in May, with about 150 district judges in the room. And the answer is nobody knows the answer. But it doesn't appear there's any legal mechanism for doing this. But so help me out here. There's no lease. How do we know that the rent is $385 per month?
Your Honor, I'm going based off of, the ledger that was provided for me or provides me by my client. It shows a past due amount of $2,187.54. And Your Honor, I believe under the Summary Proceedings Act and the 7-day demand for non-payment of rent, it does not preclude landlords from seeking or proceeding without a just cause and just under the non-payment of rent actions filed. I believe our office has filed several briefs in support since the meeting that took place in May to the district court judges outlining the difference between proceeding on a non-payment of rent action in light of the just cause statute.
All right, well, I've never seen the brief, but let's assume, so we've got 2,187.54 through June.
Through July, Your Honor.
What are our court costs here?
Court costs would be $197.54, and I apologize, Your Honor. Rent to retain is $1,990 with cost of $197.54.
All right, now speak up.
All right, give me that again. What is rent through July?
Rent, Your Honor, is $1,990.00.
All right, costs are $197.54, so we had them lumped together. So rent and costs through July are $2,187.54. All right. Miss Weaver, what's your position here?
About the
I sent
$1,120
them
check.
a check for $1,100 and some dollars. And then I also have a receipt where I had a money order that I sent back in March of the $385, which they say I did not pay.
The eviction notice says that she hadn't paid rent since.
All right, stop, sir. Stop. Unless you have a law degree, you can't represent her or speak on her behalf. You can certainly be it. But all right, so first of all, Miss Weaver, do you dispute the amount?
Yes.
And you indicate you paid $385 in
March.
March, and $1,100 on July 3rd.
Yes.
And then, all right, this other check is dated 8/3, but it isn't cleared yet. So
No.
you contend that you paid $350, $385.
I paid $385 every time,
All right, in
not
March,
$350. They increased it.
$385, and then you've got a check from July 3rd that shows you paid $1,120.
Yes.
No one is here from the park, and it would be helpful if they were.
Well, somebody cashed it because my money disappeared out of my bank account.
All right, just a minute.
Your Honor, if you would give me just a brief moment to reach out to my client to allow them the opportunity to appear via Zoom to go on this matter, because I do see the payment made on March 10th, 2025. However, I'm not showing any payment received since then, Your Honor.
Okay. All right. Yeah, go ahead. We've got another one coming up in a minute.
Okay, it should be quick, Your Honor. Thank you.
Miss College, can you hear me?
Yeah, I can hear you, hon.
All right, I'm gonna take a minute while he's doing that to advise you of your rights. Our case is coming up here in a minute. The esteemed Ryan Buckland is here on behalf of your landlord, but while we're waiting, let me tell you what your rights are. As a defendant in a landlord-tenant proceeding, including non-payment of rent or termination of tenancy, well, let me see who this is.
It's a non-payment of rent, Judge.
Yes. I've got it here. She's applied for assistance, but I've got someone else that's come in by telephone. I'm gonna just have to eliminate that. Who am I speaking with? 257-1078. Is that Mr.
Cassandra.
Cassandra Strasser?
Yes.
All right. All right. And here's Mike. Who he is. Someone's logged in as Mike. What's your name, sir?
Yes, you can hear me?
Yes.
Okay, I'm Michael Mullet.
All right. You're a plaintiff. All right, Ms. Strasser and Ms.
Yes.
College, advise you of your rights. You're each tenants in a landlord-tenant proceeding, and your landlord has filed a lawsuit either asking you to move or to pay the rent. You have the right to obtain counsel in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. Normally, a legal aid attorney is here with us, but she's not here today, probably because I set this on a Wednesday and she's in demand somewhere else. But we gave you the number on how to contact legal aid, or you can seek other legal advice. You have the right to have the matter heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at this first court appearance or make the demand in writing within 5 days of this date using the jury demand form. Pay the $50 jury demand fee unless the judge waives your requirement to pay the fee because of your inability to pay. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a federal veterans program if you are eligible. We sent you that information all with the packet. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint are sufficient. You may be able to reach an agreement with your landlord by going through mediation. If both parties are interested, the court can set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed, in which case we would file a conditional order of dismissal. Mr. Borden Sanford, while you were doing that, I used the opportunity to advise those of their rights. I don't like this case much. There's no lease. The landlord's not here. I'm not sure you have the authority to do it, but here we are. So, and now the tenant claims that they paid some money that doesn't seem to be accounted for. What can you tell us?
Your Honor, I was unable to get a hold of my client. Actually, they are calling me back right now. Would you mind just giving me a brief moment if that's okay?
Yeah, I'll skip ahead to Mr. Buckland's case.
Thank you. Thank you, Your Honor.
All right, Mr. Buckland won't mind. So let's set the two Washburn Lake cases aside for a moment. And we will address Michael Mullet, who is present, versus Donna College. This is a property in White Pigeon. This is a demand for non-payment of rent and the defendant has asked for some financial assistance. Mr. Buckland, what's the current arrearage?
Current arrearage is $5,764. And then
And court-
I show court cost of being $104.10 plus the statutory attorney fee of 75 would make it $179.10. So that added together is $5,943.10.
Ms. College, that's a lot of money.
Yeah, it is.
I see that you've applied for some financial assistance. You're considerably behind on your rent. Who have you asked for assistance?
I've done DHS and Neighborhoods Incorporated. And my boyfriend's sister's was helping me out some.
All right, the law requires that I adjourn this at least 7 days. In a case where they've actually filed the request for assistance, I have to adjourn it 14 days, which is good because I have to bump this out to August 29th, excuse me, that's a Tuesday. Mr. Buckland, that's an odd date for us to do cases. But I've set it in the middle of my vacation to come in and try to stay on top of my landlord-tenant docket. Are you available Tuesday, July 29th at 11?
Yes, I am.
Now, Miss College, you're way behind on your rent. I've adjourned it 15 days, because when you file this application, proof, we're supposed to adjourn it 2 weeks. Mr. Mullet, we're sort of all stuck with the change in the rules. But if he gets what he asked for, unless you pay the rent within 10 days of July 29th, you're subject to being evicted. That would be August the 8th. And you have to pay the entire amount. Partial payment will not cure the writ of eviction. So if you owe, and to further complicate things, when we get to August, another month's rent is going to be due, which is, so add $750 to the $59 that you owe. Unless you pay the entire amount, you are subject to being evicted, meaning you'd have 8 days or 10 days from the hearing to move. So it looks like rent has not been paid here in quite a while. February, I think is what my note said. January. Paid through January. So starting in February, you haven't paid any rent. So unless you can catch it all up, you're going to be forced to move somewhere else. Have you made any provision to try to find another place to move to?
Yeah, we're looking.
All right. Well, let me repeat, I'm going to continue this matter until July 29th. That's a Tuesday at 11 a.m.
Okay.
And if you can pay the rent, great. If you can't, you may be compelled to move 10 days after July 29th. My advice is always the same. Stay in contact with your landlord. Let him know what your intentions are. And let me tell you this also, if you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
All right, do you have any questions?
Not really.
All right, thank you. You're good to go.
Thank you.
Thank you, hon.
Thank you, Mr. Mullet. Mr. Buckland, I'll see you next time. All right, let's go back to the Washburn Lake cases. Let me remove Mr. Mullet. We were addressing file number 251158, Washburn Lake versus Weaver. Council contends that the rent through July is $1,990 plus costs. He was gonna check with his client. Mr. Borden Sanford, what can you tell us?
Yep, Your Honor, I have my client, the manager of the community, Ms. Daler, in the Zoom as well, so she'll be able to confirm, and according to our ledger, which is what we base, this action on, no payment, at least on my end. Ms. Daler, can you confirm if there has been, the alleged payment of $1,120 made?
No, the last payment I showed that was received was for $385 in March.
All right, so this calculation includes the March payment?
Correct. Your
Yes.
And what the defendant filed with that is a money order receipt, which shows it was cashed. That with the, yes, with the July, there's no money order receipt. It's simply a personal check dated July 3rd. So maybe it hasn't cleared yet. At any rate, the law says I have to continue this matter. And we're going to continue both of these. What I did for 9:30. Mr. Borden Sanford, are you available Tuesday, July 29th at 9:45?
9:45. I believe I am, Your Honor.
All right. Now, in the meantime, Ms. Weaver,
Yeah,
see whether this check clears. 1,120. You indicated you intend to pay more.
yes.
This is actually a 15-day delay, which I normally don't do, but I'm on vacation. So we're gonna go to July 29th. If you've paid everything, then you're squared away, but you need to get caught up. And if you haven't paid everything, we'll discuss it further. We'll see whether this $1,120 check clears. And Mr. Borden Sanford, I'd like to see the brief that your office did on that topic.
Okay, I will make sure to file that, Your Honor.
The consensus was we either need a Court of Appeals decision or a change in the statute to allow this, but we'll see. And if we get to this point, your lot rent is unpaid, so your mobile home would be terminated. And so it's a screwy posture that we're in right now. Under the just cause termination, you would have 10 days to move and 90 days to move or sell the mobile home. But it's less clear in this circumstance. My hope is, Ms. Weaver, that you can get all the rent paid and keep your tenancy.
Me too.
All right, do you have any questions?
No,
Ms. Daler, let me ask you a question.
Yes, sir.
Why don't we have a lease in these cases?
This company the company I work for would purchase this community in October.
Yeah.
They're currently working on getting new leases for everyone. They just haven't yet.
Well, that would be very helpful if they did.
Yes, sir.
Okay. All right, Ms. Weaver, I'll see you on July 29th at 9:45.
Okay, thank you, sir.
Thank you. All
Can
right,
I
we
leave?
have given, yes. I'll put that in the waiting room. I've got a number of other people show up for their hearings. We're at the 10:15 hearing, so we're behind schedule, but we had to wait for some matters. This is 251359 LT Washburn Lake versus Cassandra Strasser. Cassandra Strasser is here by telephone only, which is not ideal.
I'm sorry, Your Honor. I tried to get online and I couldn't, and I was running late, so I just called the number.
Well, it's our last resort, so you are here. Yeah, people practice like 1 minute before showtime. What we prefer is if you can't do it, you actually come live to the courthouse like the last lady did. But let me get everybody here. This is a similar situation. It's lot only. There is no lease, and they're asking for payment of rent rather than file under the just cause mobile home statute. Mr. Borden Sanford, what's the arrearage here?
Your Honor, I'm showing, past due rent of $2,559.43, court costs of $197.54, bringing the total to $2,756.97, Your Honor. And I will note that under MCL 600571141, it indicates circumstances which a landlord is entitled to recover possession of the rental premises through subsections A through H.
All right, that's in your brief.
That is in my brief, Your Honor.
Well, when we see the brief, we'll explore that further. Ms. Strasser, what's your position?
I have tried to contact her by phone number and the call never goes through. She sends texts periodically, but I have money orders dating back since March of this year that I have paid my rent on time since March. And I knew nothing about any of this eviction until the gentleman showed up on my door to deliver papers.
Well, let's take a look at the pleadings.
And Your Honor, I will note the last payment received was for $410 on April 7th, 2025.
All right, it says rent is paid through November. So this would be January or December forward. And the plaintiff says last payment received in March.
April, Your Honor, April 7th.
All right, sorry, yes. That's why it's problematic, Ms. Smith, Ms. Strasser doing this just by telephone, because I can't see anything that you have. The law requires that I continue this matter, and I'm going to do that. I'm going to continue it until July 29th. (2025) at 10 a.m.
Okay.
And let me tell you what the deal is. If you pay this rent, you don't need to come. If you don't pay the rent, you're unable to pay it. And you have to pay the entire amount. Partial payment does not prevent the writ of eviction. And you could be subject to being evicted 10 days after our next court hearing. Our next court hearing is July 29th. Unless you pay the entire amount of rent, by that date, you could be subject to being evicted 10 days later, which would be August the 8th. And that's a Friday. So if you've got some money orders that you contend should be applied to the rent, take them into the manager and compare your accounts to see if we can get to an account. But according to Mr. Borden Sanford, no payment has been made since April of 2025. So that leaves May, June, July, and soon to be August, probably some other months behind it. So if you have those receipts, share them with your manager, or certainly bring them when we come to court on July 29th. And Mr. Borden Sanford, if you give me the brief in that case too.
I will, Your Honor.
Because then the question is, what's the remedy? I'm evicting the mobile home, so the landlord has to move it. So we'll cross that bridge when we get to it. But Ms. Strasser, I will see you in 15 days on July 15th at 10 a.m. If you can't Zoom in, please come here to the courthouse and I'll speak to you face to face. All right? Do you have any questions?
I have a quick question, Your Honor. How would you like for my office to submit this brief in support?
Well, if you've already written it in other cases, just put this caption on it and send it for filing in each one of these cases.
Sure.
Because we asked, has anybody had a brief on this? We had two of our judicial experts in landlord-tenant, Judge Reeds and Judge Buchanan, and we had a lively discussion for more than an hour without solving the problem. So I'm interested to see if you've got some authority, and then I'm interested to know what you're asking for as a sanction.
Will do, Your Honor.
All right. Anyway, we'll take another crack at this. Maybe they'll pay the rent. And hopefully it's been October to July. They could get leases with these folks and make sure things are more clear.
Will do, Your Honor.
All right.
Appreciate
I'll see you in
the
2 weeks. All right. Thank you.
Thank you.
All right. At this point, we're 9 minutes behind, which isn't too terrible. We did skip ahead for a case. We've got some other people joining us, but George and Rita Phillip are here. I like the glamour shot better than the one with George in it here, but we will address this. Attorney Richard Herman is here from Bingham Farms.
Yes, sir.
You ever been to Centerville?
I have not, sir.
Well, you're missing out.
There's lots of time left.
You ever been to Mendon?
I have not.
Well, you really are missing out, but I know your clients, but I don't feel I need to disqualify myself in this matter.
Okay.
It does not appear that Autumn Cheeseborough is here, and I couldn't tell whether I had service. Let me look in the electronic
So,
file.
Judge, can I just interject something at the expense of trying to be transparent?
Sure.
We do have service. Your court officer, he didn't give me a proof of service, but he did give me a bill for his service. And I think the Phillips will attest to the fact that it was posted on the door.
All right, well, it's whether we have personal service or attachment.
Well, it wasn't personally served, I'm quite certain.
No,
But
it says, I think it was served by attachment. Let's
it
take a look.
was. And,
Okay.
and we did do the $13 mailing, which I think would obviate the
second mailing.
Yep, which would obviate the need for personal service. But with all honesty, Judge, I do not believe that the extra mailing was done. What used to be done by, which we used to call the first mailing. Now I don't know whether it's the first or second, but only one mailing was done. So it was attached to the door and we did mail it. It was done. The $13 mailing was done.
But the court didn't do the second mailing.
That's correct.
So we're stuck with a continuance. Mr. and Mrs. Phillip, is she still there? You're on mute, I think. Ms. Phillip, I can't hear you.
You're muted. No, now you're muted. Something wrong with your audio?
They had audio before. Nod your head. Is she still there? All right, they believe she's vacated.
But I do believe, if I might, Judge, Rita, there still are possessions in the unit. Yes, okay. They've been gone for a while, Judge.
That was done.
Oh, all right. The clerk brought me proof that she did a second mailing.
Yes.
It isn't in the electronic file.
It is.
Oh, it is? Okay.
The
thanks.
second mailing was done, but Judge, I don't believe the first mailing was.
Well, this is sufficient for my purposes.
The first
Perfect.
mailing has to be done by the attorney.
Yes. So you didn't do the first mailing, you only did the second mailing?
Correct.
Yeah.
And they were served by attachment.
And they're gone.
And they're gone.
All right, I'm gonna do the default. Defendant has 10 days to vacate.
Perfect.
Now I ask you to send me a judgment.
Do you have one, Judge?
I don't believe so. Let me look.
And I know I should know this. My staff does. I don't. Are you an e-file court?
Well, what I'd ask you to do is email me a copy of the default judgment. They have 10 days from the day to vacate or the subject to being evicted. Today is the 16th of July. They'd have till July 26th to vacate.
I think that's a Saturday.
Yeah, I usually don't do things on a Tuesday.
I
but-
actually gave them, let's see, my judgment actually says the 28th and the computer pumps it out. So I'm thinking that the 26th is a Saturday. Yeah.
All right, it is. And I usually do these on Mondays and Fridays. All right. My email address is on the notice, but let me give it to you.
Thank you, sir.
3bcivil@stjosephcountymi.gov.
Countymi.gov. Will do.
And
That'll be
it's
as soon as I go offline with you. I will email this to you.
And I'll sign it. For you, Mr. and Mrs. Phillip, if she hasn't removed her stuff as of that date, July 28th, you can start to remove her property. And haul it away or set it aside. I'm not sure what kind of stuff is there. If it's junk, you can certainly haul it all to the dump. I'd suggest you change the locks on the property. Can take possession of it after July 28th.
Should Judge, we wait until we file a writ and you sign it?
Yeah, but I'll sign it. You don't, yes, all right. If they haven't vacated, they're subject to a writ. I guess if we want to be carefuler about it, it is a default, then you can get the writ on the 28th.
Perfect.
And then they can take possession.
My next question, I'm sorry, Judge, this is the first time I've ever been in your courtroom, so I'd rather be safe than sorry. Once you sign the order of eviction, does your bailiff come out and throw the stuff out, or does your bailiff come and watch them do it, or does your bailiff not come out at all?
No, our bailiff comes out. He's excellent.
Okay.
They sometimes do it in conjunction, but he will coordinate with the landlord. Often the bailiff comes out and they just put all the stuff out in the street like a garage sale. But very often the landlords just get a dumpster and clean it out themselves.
Perfect.
All right. I think I'm okay with that default with the second judgment or the second mailing and the defendant is not there. All right, well, if you come to Centerville or Minden, I suggest you do it in the summertime because there's not much to see here in January, but otherwise, I've been to Bingham Farm, so I got that on you, but maybe someday you'll get sent to Centerville.
And if I do, I'm going to try to make it during the work week so I can shake your hand. I've never met you before, and it's been a pleasure.
All right, thank you. I'll see you again perhaps.
Okay.
Mr. and Mrs. Phillip, good luck. Stay in contact with your lawyer.
Thank you.
Thanks. Rita, why don't you give me a call as soon as you get off of this, okay?
Yep.
Thank you,
All right,
Judge.
now
Have a great day.
We're working on it. All right.
Okay.
Thank you.
All right, now we've got a couple of Bradshaw cases and let's see who all is here. We've got the esteemed John Bradshaw. We've got Diane Coy, one of our tenants. We've got Kelly Pedler, one of our tenants. We've got the manager at Erie Street and we have the manager at St. Joe River. Good morning, Mr. Bradshaw.
Good morning, Your Honor.
We're a little behind, but not terrible. Let's go to our advice of rights. Ms. Coy and Ms. Pedler, you are defendants in a landlord-tenant proceeding. You have certain legal rights in that case, one of which is your right to have a right to hire a lawyer. If you cannot afford an attorney, you can ask legal aid to represent you. And normally they're here with us, but we're doing this on an odd day. So the legal aid representative is not here. You have their number, and if you wish to call them, you can contact them or seek other legal advice. You have a right to have the case. You have a right to have the case heard here in St. Joseph County, where the property is located. You have a right to demand a jury trial. If you do wish to have a jury trial, you have to tell the court at this first court appearance or file a written demand within 5 days and be prepared to pay the $50 jury demand fee, unless the judge waives the fee for your inability to pay. If it is a demand for non-payment of rent, which both of these are, you do have the right to seek assistance, financial emergency housing assistance. There frankly isn't very much of it left. It was quite prevalent during COVID, but there are a few sources. One is the Michigan Department of Health and Human Services. One is a local coordinated entry agency in our county, that's Community Action. Housing Assessment and Resource Agency, that's Neighborhoods, Inc. Or federal help from homeless veterans. If you are a veteran, we sent that information to you. Ms. Coy, would you sit down in one spot? You're making me dizzy here.
Yes.
I'm gonna get vertigo and file out of my chair. All right, you have your legal assistant there with you. All right, you do not need a judgment against you to receive such help. The summons and complaint are sufficient, despite what the DHS might tell you, and you've already received that. You may be able to reach an agreement with the landlord by going through mediation. And if both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed. Mr. Bradshaw's firm does a lot of these conditional order of dismissals. And if such an agreement could be reached, perhaps a conditional order of dismissal would be filed. So Ms. Coy is first at 1040. File number is 251429. And the manager from St. Joe River is here. He's listed as user. I forgot your name, sir. What's your name? Well, I don't know his name.
Daniel Hartley.
Okay. All right, this is demand for non-payment of rent. This wasn't terribly behind at the time of filing, but it was over $1,700. Mr. Bradshaw, what's the current status?
For Ms. Coy, Your Honor, the current amount due through the month of July is $733 in rent. There's $182.23 in court costs. So the total amount due through the month of July is $915.23.
Ms. Coy, do you agree with that?
Yes.
Are you gonna try to pay it?
Yeah. Yeah. So I had to get a right to canvass to give Social Security my new information that they would give me my back pay. That I'm going to pay it.
All right. It looks like you've made some payment.
Well, the last.
The law,
Yeah, sorry.
the law requires that I adjourn this, and I'm going to adjourn it to Tuesday, July 29th at 10:10. Mr. Bradshaw, again, that's an odd date for us. Can you accommodate that time and date?
Yeah, we'll make it work somehow, Your Honor. And in the meantime, we'll do some homework and try to determine what the issues are as far as payment, when it can be paid, and try to come up with a conditional dismissal that will satisfy everyone.
Do you hear that, Ms. Coy?
Yes.
All right, they may be contacting you to see if they can work out some sort of agreement. If they can, could do a conditional order of dismissal. Of course, if you pay, then we don't need to worry about it. And then your rent will be due on August 1st as it is the first of each month. So we're going to do this again. You logged in early and on time, and I could see you, and I appreciate that. We're going to do it again on Friday, July 29th at 10:10. You should get a new notice for that. Do you have any questions?
Not right now.
All right, stay in contact with your manager, and Mr. Bradshaw's office may be contacting you. Okay?
Okay.
All right, stay inside with air conditioner on, all right?
Absolutely. Thank you.
Okay. All right, next is Kelly Pedler. Same circumstance, different complex. This is Erie Street Apartments, what we used to know as. It's now Three Rivers Limited. File number is 251432. Mr. John Bradshaw is here for the plaintiff. Kelly Pedler is here. And the manager. And again, I've forgotten your name.
It's Shayna.
This is also a non-payment of rent case. This looks like market rent, $881. And there's a substantial arrearage. Mr. Bradshaw, what's the status here?
So yes, Your Honor, and Ms. Pedler, the current amount due through the month of July is $2,653 in rent. There's $183.28 in court costs. So the total due through July is $2,836.28. That is $2,836.28.
What was the rent portion?
$2,653.
All right, Ms. Pedler, do you agree with that?
Yes.
What's your plan?
I'm trying to figure that out. I'm not really sure at this point.
All right, let's talk about that. I gave you a couple of resources to ask for emergency financial assistance. I'm going to adjourn this matter. I usually adjourn it 7 days. I'm going to adjourn it 15 days.
I did try to get assistance and I can't qualify through DHS for any assistance.
Well, the law requires that you pay the entire amount or you're subject to being evicted.
Right.
Which is rough.
Yeah.
So you may need to plan to move to another place. When
Yeah.
we have the hearing on July, it will be July 29th at 10:20.
Okay.
And if you can't pay the rent, you would have 10 days from that day to vacate or be subject to being evicted.
Okay.
Now, my advice is always the same. Stay in contact with your manager and let them know what your intentions are. And if you can't afford to stay there and you do, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
Now, our next hearing is July 29th. You would get 10 days from that day to vacate or be subject to being evicted.
Okay.
And that would give you until August 8th to move before you'd be subject to being evicted.
Okay.
Ma'am.
All right.
Edler, does Shana know have your contact information, your email and your phone number? Does she
Yes.
Okay, great. I'll get that from her and I'll be in contact with you.
Okay, thank you.
All right. Very good. All right. I think that finishes the Bradshaw cases. And you guys are good to go.
Thank you, Your Honor. I appreciate it.
Thank you. See you next time. All right, we've had a host of people join us for our next batch, including Meg Bauer is here. Meg, as you know, that we don't usually do these on Wednesdays. I just assumed you were caught up somewhere else. And here we are.
Judge, is it possible that you can put me and Miss Pantoja in a breakout room? I have actually been communicating with Miss Pantoja and Caitlin and Scott to see if we can't resolve that matter.
Do you want me to put you all in the same breakout room?
I know what Scott's offer is. I just wanted to make sure Miss Pantoja got logged in on time, so I haven't been able to.
Sorry, Miss Pantoja, would you unmute your mic?
Yeah.
All right, I'm gonna put you and your lawyer in a breakout room. In the meantime, I'll skip ahead to the next case. And we'll come back to you guys. Good morning, Ms. Thornton and Mr. Larkins. I'll be with you in a minute.
Thank you, Judge.
All right, now we have several other defendants who are here for our 11 o'clock cases. Let's see who's here. We have Harley Polling. Is that you?
Yeah.
Oh, I spelled it wrong. All right, I got Harley Polling. Then I have Shannon's Galaxy Note. Who am I speaking with?
Harley Polling.
No, I got you. I'm trying to identify our next person. Shannon, somebody. Then I have Adriana Smith. That would be Kent Anding.
Yeah, I'm here.
All right, let me give you a correct name. And I I still can't figure out who Shannon's Galaxy Note
Can you
is.
hear us?
Yes,
Okay, we are Shannon, the Galaxy Note,
yes.
Shannon and Linda Case. We should have TV on.
All right.
I can't barely hear you.
Oh, I can hear me. Let me see. Linda, what's your name now?
Shannon and Linda Case.
Okay. Let me give you.
Put on speaker somehow. Let me see. How to do it where I can hear him. Okay, there. This is the first time we've ever used it.
All right, well, you're an expert now, so let me bring in the next person.
I don't
Yeah,
want to.
That's not good.
No.
All right, I got a bunch of defendants here. Good morning, Mr. Burns. We're waiting on some other parties, but while I do that, let me advise Ms. Poling, the cases, and Mr. Anding of their rights as a tenant in the landlord-tenant proceeding. You've all been brought to court on a landlord-tenant proceeding, either a termination of tenancy or a non-payment of rent. I think these are all non-payment of rent cases. As such, you have certain legal rights. You have the right to hire an attorney. If you cannot afford an attorney, a legal aid attorney may be available to help you. Or you can seek other legal assistance. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. So far in my 40 plus years, nobody's ever done that, but maybe someday somebody will. And if you do demand a jury trial, you have to do it today or file the demand within 5 days. And in either case, be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a veterans program. We sent that information to you. You do not need a judgment against you to receive the assistance from the places listed above. Copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with a landlord by going through mediation. If both parties are interested, the court can assist in that process. And you may be able to reach an agreement which would result in the filing of what's called a conditional order of dismissal, and the court could assist in that. So let me address this also. This is filed.
Find it.
All right, Ms. Poling, we're going to do your case. Ms. Poling?
Yes.
All right, focus. We're about to address your matter. Centerville Malone Park versus Haley Poling. The file number is 251415. Attorney Michael Burns is here for the plaintiff. The manager is also here from the park, Jessica. And the defendant via Zoom. We had another one of these this morning, Mr. Burns. It was another law firm. Your firm also does a lot of cases around the state. This is a non-payment of rent case in a mobile home lot only case, which we're not even sure can be done, but we've been struggling with it.
And to that end, Your Honor, I know a couple other district court judges have brought that to our attention. We've briefed this issue regarding the non-payment of rent case versus just cause cases, specifically relating to manufactured home non-payment of rent cases on lot rent. If the court is interested, I don't mind sending a generic brief, or if the court wants it specific to this case.
I'd like to see it. In fact, put this heading on it and send it.
Yes, Your Honor.
We had, as you heard, we had a large discussion of this at the judge conference in Detroit in May. And judges were all over the place and we didn't come to an answer. So judges were going to start having the law firms brief it. The consensus was we either needed a court of appeals decision or a change in the statute or court rule. But I'd be more than happy to see your brief, and I would ask that you would send me one.
Yes, Your
So
Honor. What would
let's
you like the
talk
heading to
about
be?
let's talk about this. What is the arrearage here?
Your Honor, we're claiming rent to retain of $2,224.44, costs in the total of $170.05 for a total of $2,394.49.
Through July?
That is through July, Your Honor.
The other question, Mr. Burns, becomes what's the relief?
The relief, Your Honor, is possession of the rented premises. So we're not asking for possession of the manufactured home itself,
I
Your Honor.
understand. So then somebody's got to move the trailer off a lot.
Yes, Your Honor.
So, okay. Miss Poling, what's your position?
We weren't even aware that we could move the trailer off the lot or told anything of such. We haven't been able to make payments on rent because they have our account closed to either full payment or no payment at all. I have paperwork showing our bank statements. My wife has a garnishment on her paychecks, and she missed 2 court dates, so I had to bail her out, which is $500 a piece.
What's her name?
Brittany Poling.
Is she on the lease also?
No. They never put her on the lease.
At least you have a lease, which was better than one of the cases I was dealing with earlier. There's another way to do this, to file a just cause termination for 3 lates in a 12-month period, in which case the order would say you would have 10 days to move and 90 days to move or sell the mobile home. Some firms choose to do it this way. It made sense during COVID because they could get emergency housing assistance and they could redeem.
I tried to get assistance through DHS and they just straight up denied me. Said we made too much, even though my wife has a garnishment on her check and I only work 22 hours a week. Because I'm mentally disabled.
Well, you seem to be doing quite well here.
It just keeps me from working a lot. I can't work too much.
All right. All right. Well, the law requires that I continue this matter to at least 7 days, but I'm moving everything to the 29th. So I'm going to continue this to July 29, 2025 at 10:50. Now, if you can't pay the rent within 10 days of July 29th, they're going to ask me to allow them to move your trailer off the lot.
I wasn't even aware that we own the trailer. They told us to get caught up on rent, and then we owed $2,000 more to own the trailer. The offer that they were giving us was $1,000 for our keys.
Oh, they offered cash for keys?
Yeah.
Well, that could be a pretty good deal.
Your Honor.
Yes.
They do not own the trailer as of yet. And on the lease, it states that the mobile homes cannot be moved. So her option would be, if they were to pay off the mobile home, then, and if they get evicted still for non-payment of the lot rent and stuff, then we would either help them sell the mobile home or they would have to sell it on their own.
I don't think you can do this. I don't think you can do what you're doing legally. Ms. Bauer, they could
I am
benefit.
happy to consult with them, with the defendants. We will have a settlement to put on the record, so the defendants might have to wait, but I'm absolutely happy to consult with the litigants.
From my understanding, she still owes on the mobile home.
All right.
Can we possibly meet up with is she the attorney or?
Yes, you just stay
Okay.
here with, and
Okay.
either way, we're gonna continue this matter until July 29th at 10:50. Ms. Poling, you just stick with me. And when we finish Ms. Bauer's other case, I'll let you speak to her privately in a breakout room.
Okay.
So I'm not sure I even have all my facts straight. It's apparently rental purchase. I'm not sure what we got here. But this action is for lot only. This firm and at least one other firm, probably several others, have briefed this issue, but there's no court ruling on it. There's no district court ruling that I'm aware of. There's no circuit court ruling, and there's certainly no court of appeals ruling. But we'll see. We'll muddle our way through the weeds and we'll try to get to a solution.
And to that end, Your Honor, for the brief, do you want me to submit it generally to the court as a blank, or do you want it included as part of this case record?
I'd like you to put this heading on it.
Yes, Your Honor.
All right, and that'll help.
Judge, just because I was slow to start taking my notes, adjourn to July 29th.
Yes. Again, that's an odd day, Meg. That's a Tuesday. But this Wednesday and that Tuesday are because of my trip.
I've got Tuesday on my calendar.
All right, thanks. All right, thank you, Mr. Burns. I'll see you next time.
Sounds good, Your Honor. Thank you for your time.
All right, we're gonna go back to the case that we had tabled here for a minute. Richmond. Miss Richmond, Mr. Poway did call. And I told him to come back at 11, so I'll call him when we go on the other case. Let's recall the matter of Larkins v. Kurth. File number is 251309 LT. Let me list all the players. Caitlin Thornton, the manager, property manager, is here. Mr. Larkins, the owner. Meg Bauer. And Lindsay Pantoja, who is the occupant, but not the leaseholder. We discussed this matter at length last.
I'm sorry, Your Honor. May I be dismissed since this is not a...
Yes, you're free to go.
Okay, thank you.
All right. Last week, I didn't want to bump this all the way until I got back, so I stuck it in here in the middle of a already busy morning. Meg Bauer has consulted with the defendant and they've been in contact with the landlords. I'm advised we have a settlement to place on the record. Ms. Bauer, I'll defer to you. What's the terms?
Thank you, Your Honor. And because I have yet to file a formal appearance, I'll state my appearance for the record. Attorney Meg Bauer, P84816, appearing on behalf of defendant Lindsay Pantoja. At this time, the parties have agreed to a conditional dismissal. The terms of the conditional dismissal are that Ms. Pantoja does not owe rent, but she agrees to vacate the premises 30 days from today, and she agrees that Mr. Kane Hecht will not be on the property during the duration of her occupancy. The terms further state that if Ms. Pantoja violates this agreement, then Mr. Larkins can default her under the terms of the agreement and seek entry of an immediate order of possession and an immediate sheriff's order. I propose that I proposed to Mr. Larkins and Ms. Thornton that I draft those terms this afternoon, send them over for their approval to make sure they match what we've put on the record. And if we're all in agreement that that's what we put on the record, then we'll send it over to you so that it can be executed forthwith.
So 30 days from today would be August 15th. Is that correct?
Truthfully, Your Honor, we didn't look at the calendar. We were talking in raw numbers.
All right, well, it is. So this is an odd and generous plea agreement. Ms. Pantoja is not on the lease. Mr. Kurth was on the lease. He left. She's there, not paying the rent, having other people in there. And by this agreement, she gets to stay there for free through July and the rest of August, I guess, and doesn't owe anything. They just want her to vacate. Mr. Larkin, do you hear everything that was said?
Yes, Your Honor.
And you agree with those terms?
Yes, Your Honor.
At this point, you just want her out.
Yes.
Ms. Pantoja, did you hear what was said?
Yes, sir.
You get free rent for a while, I guess. They don't want your friends there that have been barred from the place, which includes Mr. Koenig. You have to vacate by the 15th of August, or they're going to get a writ and have the sheriff come put you out. Do you understand?
Yes.
All right. Ms. Bauer is going to submit what's called a conditional order of dismissal. There is no urgency on this because the move out date is August 15th. But if you submit it, I'll sign it. But essentially, Ms. Pantoja, no barred visitor shall be coming to the premises, and you have to vacate by August 15th. Do you understand?
Yes, sir.
Do you have any questions?
No, sir.
All right, you're free to go.
Thank you.
Thank you, Scott.
You're welcome.
Caitlin.
All right, I'll await that order, Meg. All right, Ms. Thornton and Mr. Larkins, I'll see you next time. Thank you.
Thank you, Your Honor.
All right, sometimes the landlords have to give something to get something, and I guess at this point they're gonna get her out. Meg, I'm gonna put you in the breakout room with Miss Poling. I don't know if you've been seeing these landlord mobile home cases where they're filing for, we've been struggling with these for years, but during COVID, it gave people a chance to redeem it. But I'm not sure whether they can do it. So,
I
all
will
right.
say that I have another case out of this park, and I'm concerned about what I'm seeing.
All right.
It's
I'll
any
take a
more.
look at this. So Miss Poling, hit the button that says join. All right.
Thank you, Judge.
Now, I don't see Mr. Thornton on Mr. Anding's case. That's not set till 11:30. But we have Terry Richmond at 11:10, which is Shannon and Linda case.
Yes.
All right, let's talk about this case. Elaine, I think you took away Mr. Powey's. No, I've got it. Never mind. I set it aside. All right, this is a tenancy at Railroad Street.
Right.
Apartment B.
Yes.
I've advised the defendants of their rights, Miss Richmond, while we're working on some other stuff. So what's the arrearage here?
Okay, rent is $1,819.35. Court costs of $183.23, with a total of $2,002.58 through July.
That's not hard. I don't know why everybody else can't do that. Ms. Case and Ms. Weaver, they allege that you owe $2,002 to pay your rent up through July. What's your position?
No, our position is we didn't even know about this in the beginning. We have informed delivery and we weren't notified, I guess, on the 8th of June that they were saying that we were supposed to be paying $830 a month throughout this whole time that we've lived here. And our lease is $800 a month, which we've been paying regularly. I have the lease in front of me for $800. And our rent wasn't due for June until it wouldn't have been late until the 9th, which we paid it on the 8th. And I guess the only thing that we agreed to is that there was a $450 check come back on June 11th. And we'll pay the $30 too, which makes it $480. And we also have July's rent. We just haven't paid it because of this going on right here. Because we don't agree that we owe them $30 a month for the whole time that we've been here. And these numbers are way off.
Right, let me look at the actual filing.
Okay.
The lease does say $800.
Yes,
Right, and we raised the rent on April 1st.
We were never told of that, and that wouldn't even account to the amount of money that they put on the one that they stated that they filed through mail that we never got on 6/8. The amount then was saying $1,244.35, and $30 a month from April 1st would not account to be in that month.
But you carried a balance since you moved in.
Slow down.
We're paid
Slow down. This is hard to do in the abstract by talking. So your lease expired in March, and their contention is that they raised the rent in April, which they can do. They have to give you some sort of notice. So the landlord contends, don't just interrupt. I'll give you a chance to speak, but we're in a courtroom. We're not sitting around the kitchen table. So, landlord said rent raised April 1. Ms. Richmond, how do we break down this $1,819 that you claim is due?
Well, they have arrearages since they moved in. And they've just carried a balance. And then I got a return check. And then the check charge is $25.
How much of the balance have they been carrying?
It started at $240 and it's at $340. Well, they didn't pay the $30, so then that added another $100. So they have a balance of $474.
All right, let's back up.
Okay.
All right. Were they paying $800 a month through March?
Yes.
All right. As of March, was there an arrearage?
$344.35.
All right, $344.35 as of March.
Mm-hmm.
And then in April, rent was increased by $30.
That's correct.
How are they notified of that?
Mailing. But we have a problem because if we mail it to the address, it comes back. Then we mailed it to the post office box and it came back. Lydia is here and she sent them an email saying we were getting their mail back and we never heard anything since then.
All right, so that part of the issue would be 30 for April.
May, June.
And July, which is 120. Which is in dispute. All right. And now July's rent is due. Now,
Correct.
ladies, you heard me say this. The law requires that I adjourn this to a second date. It would be helpful if you guys could talk in the meantime and agree on how much the arrearage is. Also, it's not very helpful if your landlord can't send you a letter. You said something about restricted delivery. What's that about?
No, I said we
Go ahead,
have
I'm sorry.
we have informed delivery, and it shows like anything that we've gotten in the mail. Plus, they have 2 phone numbers for us, and we haven't received a call. They had put in a few different eviction notices on our door in the past, which we've cleared them up. We have those. We went in and talked to them about it, and it was a mistake. We paid that up, have a
All right.
receipt.
I
But
hope that can happen here.
So what
Yeah.
is your mailing address?
Well, don't put it out over the internet.
No,
Live feed.
contact us.
But you don't get mail at this Railroad Street address.
no, it comes to the post office box that we gave them.
But we're
All right.
getting it back.
I don't understand that, but
Well, call me
Normally-
with your post office box number.
I will, but not like over the internet, like you
No,
said.
no.
And we communicate with Lydia through text. We communicate with you guys through phone. That's why we wanted to meet with you last week before we had to go through this, because this is not correct, just like the 2 times before that
All
we've
right,
had.
well, if it can be straightened out, we'll attempt that.
Okay.
All right, I set my last one.
The 29th at 9:30.
Yes. Let's see what I got there.
Do you have any time left?
No, I'm gonna set it for the 29th at 9:15.
Okay.
9:10, I'll say.
Okay.
No, wait a minute. I've got a sentencing in there. 9:20.
Okay.
July 29, 2025 at 9:20. I'm cutting it close. I'm just coming in for that one day and I've got a bunch of stuff crammed in there. All
I'll
right.
try to make it easy for you.
Okay, now my recommendation would be that you all talk to each other before that date. Maybe you could agree on amount, maybe you can't. Sounds like you're Ms. Case, Linda, it looks like Shannon, you work at American Axle,
Yes, sir.
and Linda, are you employed also?
I'm retired.
It's
I'm
'cause you're-
70 years old.
Well, you're my age, so you graduated from Centerville the year I
That's right.
graduated from Three Rivers, so that, I wouldn't say that's old, but, congratulations on getting the finish line.
Yeah.
Okay,
I'm older than
let's see if we can sort this out. Anyway, we'll revisit it on July 29th at 9:20
July
Okay.
29th at 9:20
Yes.
a.m.
AM.
Okay.
You'll get it. All right.
Yes, sir, because we do have the July's rent and the 480. I don't dispute
Well,
that.
then maybe we can get very close to it. So,
Yeah, I hope so.
all right, we'll take a crack at it in
Okay.
15 days.
All right, thank you, sir.
All right.
What happened to
Let's call,
Frank?
I'm gonna call him. He, this is not ideal. Shut this off.
Hello?
Hi, this is Judge Middleton calling for Frank Poway.
Yep.
All right, Mr. Poway, this isn't ideal, but we'll do the best we can. We were here several hours ago on your case, And Terry Richmond is here with me. She indicates that through July, you owe $945.52 in rent, $116.66 in court costs, for a total of $106,218. Do you agree with that?
No, I don't.
How much do you
I don't
believe?
know what much rent and whatever court cost is.
I don't know what he said.
He believes he owes 1 month's rent and court costs.
Well, coming into June, he owed $376.
So June, 376, and then July's rent of 730.
I paid June's rent was paid.
She says there was a shortfall of 376.
No, I paid the other half.
Then he
And
paid
money order.
three.
All right.
He
Go
paid
ahead.
$350. So that left a balance of $131.06. The gas is back in my name, so I have a gas, July's rent, electric of $146.45. His son was living there. His son moved out and took the utilities with him. So when that happens, they automatically go back in my name.
All right, Mr. Poway, some of this are utility bills. So we're going to continue this matter until July 29th.
All right, hopefully I could be out of there by then, Your Honor. I'm just trying to get out of the house.
All right, very good.
I know I didn't have the money this month, and he's got a month and a half deposit, so he's not out any money right now. I mean.
All right, well, I'm going to continue this to July 29th at 9:35. And if you move, you just turn in the keys and give your forwarding address to the Richmonds within 4 days of your moving. So that gives you 15 days to vacate. You understand?
I'm trying. It's all by myself. It's a 3-bedroom house, Your Honor. I mean, it's a lot of stuff.
Well, if you don't move, we'll address it on July 29th.
Do everything I can.
Okay. All right, I'll put your number in here. If you can't connect and you want to be here, you got to come in here. I don't like doing this.
I will next time. I'll make sure I got it right up there.
All right. If you move, you don't need to come. If you don't move.
Okay. All right.
All right.
I'm gonna do my best to try to get out of there. I really am. I've started moving.
All right.
It took me a while to find a place. So when I finally did find a place, I don't have any money. It's hard to move if you don't have any money.
Yes, I agree. And it is hard to find a place.
And so I'm working every single day. I'm coming back. I'm moving stuff, and they're paying me by the day. So I can do that, but I just don't have a lot of extra money.
All right, well, stay in contact with your landlords or Lydia and let them know what your intentions are. If you do move and turn in the keys, we don't need to even have a hearing.
Right, I talked to Larry yesterday, matter of fact, and told him, and he's like, I want you out sooner, and I'm like, Larry, I'm trying everything I can.
I understand. All right, well, they have a waiting list. They've probably got somebody waiting to come in and rent this unit.
Yeah.
But you do the best you can and you stay in contact with your landlord, okay?
Okay, I will.
All right, very good. Okay.
Thank
we're
you,
good to-
Your Honor.
Thank you.
Thank you, Your Honor.
All right, thanks. All right, now I think we're kind of caught up. We have 2 matters left. Kent Anding is here and his matter is set for 11:30, but I don't see Mr. Thornton, and that's unusual. And then I have Ramos versus Worthington, which is set for 11:40. The manager, Judy, is here from Walnut Meadows, but Mr. Thornton is not. And that's not like him at all. Mr. Anding, don't go away.
And Judge, I'll hang out for the rest of the docket. I did also have a personal appointment this morning, so I jumped right back as soon as I got back.
I just figured you were in another court.
What does that mean?
In fact, Lance sent me some stuff this morning. Let's see what's going on. He's usually not late. I have the landlord, Yesenia, in our next case, but I don't have the defendant. I've advised Mr. Anding of his rights. Let me call Lance, see what's up.
This Lance?
Good morning, Lance. This is Judge Middleton. We got a hearing at 11:30 on Walnut Meadows and Anding, and I didn't know if you got caught up in something else.
I did. I'm sitting here drafting a document and didn't pay attention to the clock. I will put my tie on and get on in 2 minutes.
All right, thank you. Bye.
Yep, bye.
That's a mark of a good lawyer. They're working so hard they can't keep track. All right, he'll be here momentarily. While we're waiting for him, Mr. Anding, let's talk about what they claim the arrearage is. Why don't you come back and join me? Mr. Thornton does these very helpful accounting. He calls them a judgment information. Their contention is you owe July's rent of $800, a late fee for July, June's rent of $800, and a late fee for June, which is a total of $1,690. $265 water bills. Water is expensive in Three Rivers, and court costs of $197.33 for a total of $2,017.33. Do you agree with that?
No, sir.
All right. Now you got someone with you. Is there another occupant in that apartment?
Yes. No, we're not. We're actually not in the apartment anymore. We left. We moved. She actually was living here at the apartment with me, but she was not on the lease, and they were aware of that.
All right. What's her name?
Her name is Adriana Smith, and she knows a lot that's going on with the whole situation as well.
So you've already vacated?
Yes, sir.
She knows that.
She knows that. I notified her that before she even sent the court mail.
When did you vacate?
Remember what day that was?
I do.
I'm not sure on the exact date, but I can find the date for you.
All right. Well, the law says when you vacate, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. And
yes, sir. I did not know that.
all right. Here's Mr. Thornton. This is file 251458. Mr. Anding is here. Your manager, Judy, is here. I have advised him of his rights previously, and we were going through your judgment information form. His contention is that he has vacated the premises, and he disputes the amount. I think we can solve that. Mr. Anding, do you have any possession of them having immediate possession of the premises?
Hold on, can you say that again?
Do you have any objection to them have immediate possession of the premises?
No.
All right. What I propose, Mr. Thornton and Mr. Anding, is to simply do a possession judgment using your numbers. Now, let me explain this, Mr. Anding. I'm going to find, just for purposes of possession, through July, that you owe $1,690 in rent, $130 in utilities, and $197.33 in court costs, for a total of $2,017.33. Now, that's if you wish to stay there. If you wish to stay there, you need to pay $2,117, but you've already vacated.
Yes,
So
sir.
this is possession only. I'm going to put plaintiff may take immediate possession. This is the important part. No money judgment is entered here today, Mr. Anding. I'm not ordering that you pay anything. I'm ordering that you vacate, and you've already done that.
Yes, sir.
Now, you're supposed to give your forwarding address in writing and turn in the keys. Apparently, you didn't do that. So there's a dispute about when you actually vacated. You're not even sure exactly when you did. But at this point, you've vacated. You don't wish to pay rent. You don't wish to stay there. They can have immediate possession of the premises and clean it up and get ready to re-rent. They can apply your security deposit to any unpaid rent or damages. If they're going to sue you for other damages, other rent, we'll have a hearing regarding who owes who how much money. That's not today. So we don't need to nail down how much you owe and how much they believe you owe. You're simply agreeing to relinquish the property. They can apply your security deposit. And what triggers the security deposit law is you turning in the keys and giving your forwarding address. So you need to do that.
Yes,
Then
sir.
if we're going to fight about June's rent or July's rent, we can have a hearing at a later date. But you agree that they may have possession of the premises. Is that your understanding?
Yes, sir.
All right. Now, you're not represented by an attorney, and we just agreed on a consent. When a party is not represented by an attorney at the time of the consent proceedings, the defendant may move to set aside the consent judgment within a 3-day period. Such a motion stays the judgment until the judge decides the motion or dismisses the case. So, Lance, actually, it's 3 business days from today under that consent rule, but we don't have to come back. He relinquishes possession. If you wish to sue for damages, you can do that. Mr. Anding, you need to give him your forwarding address.
It's 109 North Grant Street.
Avenue.
North Grant Avenue, Three Rivers, Michigan.
Right now. All right, Mr. Thorne, does that make sense to you?
It does, Your Honor.
All right, Mr. Anding, you're good to go. You vacated. They've now got your address. If they're going to sue you for money damages, it will be at a subsequent hearing.
Okay, so that means we'll have another hearing about the whole situation. And
Well, if they decide to, they may just let it go and call it good. But if they decide to sue you for additional money, we'll have an additional hearing.
Yes, sir.
All right, Ms. Smith, best to you as well. You guys are both good to go.
Thank you, Your Honor.
Appreciate you.
My apologies to the court for not signing on timely.
Well, that's not your style, so I knew something was up. But I said, that's mark of a good lawyer. He's working so hard on a project, he got absorbed in it.
Yeah, I was drafting a document and I was really into it. So
now you got to start all over again. But anyway, we got
Thank
this
you.
matter resolved. Thank you.
Yeah, bye.
Judy, you're good to go also. All right, we're down to our last case of the day. It's Ramos versus Worthington. And someone is here as Mama. Ooh. Are you Steve Worthington?
I'm his wife.
Say that again.
I'm his wife.
All right, and what's your name?
My name's Colleen. Do you need Stephen in here?
Yeah.
Let him know you're here.
Yeah, I'm here.
Thank you. Have a seat. All right. Didn't you guys evict your grandsons a couple of years ago? Was that you two?
No, sir.
All right. You had some grandsons you couldn't get to move out. Well, Mr. Worthington, go ahead and have a seat. This is Yesenia Sanchez Ramos versus Steve Worthington and Colleen Worthington. It is filed as a termination of tenancy. So let's talk about this.
I've spoken with Mr. Santana.
All right. Hold it a minute. I've got to tell you this. As a defendant in a landlord-tenant proceeding, including a termination of tenancy action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, you could request that legal aid represent you or seek other representation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to have a jury trial. If you wish to have a jury trial, you have to tell me at this first hearing or make the written demand in writing within 5 days of today. And pay the $50 jury demand fee unless the judge waives it for your inability to pay it. You may be able to reach an agreement outside of court by going through mediation. If both parties are interested in that, the court can assist. Also, you may get what's called a conditional order of dismissal if the parties are able to agree on the terms of dismissal. So let's talk about this. This is a property on Washington Street in Constantine. I don't
Sturgis,
have.
Michigan.
What's that?
It's in
Sturgis.
Sturgis, Michigan.
Yeah, I don't know why I wrote Constantine. It's in Sturgis. There is no lease. Ms. Sanchez Ramos, is there a lease?
No.
They were paying the utilities, so Santana said that he couldn't give us a lease because they were responsible for the utilities. I have spoken with Mr. Santana.
All right, just a minute. Who is Santana?
My husband is here with me.
All right. How long have you guys lived there?
Since December 18th.
Of 24?
Yes, sir.
Was there ever a lease?
No, sir. It took me quite a while to get something from Mr. Santana for my husband on his SSI.
All right, now they want you to move. If you don't have a lease, you have a month-to-month tenancy. And they served a notice to quit on you in May 19th. Saying we want you to move or we're going to file a lawsuit. Well, you didn't move. And on June 30th, they filed this complaint. Once they file a termination of tenancy action, they can't accept any rent. So they want you to move. What's your position?
Okay, I have spoken to Mr. Santana, and he said he wanted it to go through court. So he knew the days that he would be getting money, because when they served us the first paper, we were paying him cash. The last payment we paid him, then we got the eviction notice. 2 days later, I have spoken with Mr. Santana. I have $950 right now that they can get picked up. He said he would be willing to work with us, but he had to have an exact day to be able to get more money. I start Little Caesars this week, but I won't have a full check. I'll get a check on the 1st, which will only be for a few days.
All right, well, all right. All right, stop. Stop for a minute. All right, Mr. and Mrs. said, this ain't the way to do this. You need a lease. You need a lease that protects you. You need a lease that protects them. You tell them one thing and then you file something else. Once you file a termination of tenancy, you can't accept any rent. However, if you do accept rent and make some agreement, that's okay with me, but we can't go forward on this case. So if you can agree with Mr. and Mrs. Worthington that they pay you $950 today and $250 next week or that sort of thing, but if you accept any money, it ends this case.
I'm not wanting to move. I have paydays that I can guarantee payment. We were paying by Cash App. Then he said he didn't want his Cash App used. He wanted us to pay cash.
All right, now let me stop right there. I wouldn't pay cash. I would pay with a certified check or money order. So you've got a receipt. Like I said, that ain't the way to do this. It leaves you unprotected. It leaves the landlord unprotected. I would pay with a bank withdrawal or a certified check or money order. I would advise you not to give them green cash. I advise you not to take green cash unless you give a receipt. But I'm going to adjourn this matter for 2 weeks. If you guys can come to some sort of an agreement that you get to stay there, that's okay with me.
Your Honor.
Yes, sir.
Hey, this is Santana Longoria here. So just going a little bit back, there was never no lease because they were in quite of a pinch that they could not pay the deposit for the bill. So we went ahead and tried to help them out. Now, we've tried to work with them several times as to being behind on rent. Mrs. Colleen and Steve can let you know how many times it's been more than several that we've tried to work with them, but every time they drop the ball and they don't say what's going to happen. So at this point, after talking with my wife, who is the owner of the property, she's saying that she will not accept rent and she wants to go ahead and move forward with getting them out.
All right. Now, you don't have a lease. They gave you a proper notice to quit with more than a month's time to vacate. You didn't.
Yes, sir. They were taking payments before I got the actual eviction notice.
All right. They can do
And then
that.
Mr. Santana told me 2 days ago that he wanted it to go to court so it could be logged on the paydays for me to get the rent paid up in full. And he would work with us, but this would be the last time.
Well, apparently she's the owner and she feels differently about it. They want you to move. I'm going to adjourn this until July 29th. They don't want you to pay money. Use your money to go to your next place. They want you to move. If they accept money, this case is done. They have to start over again. At this point, they don't want to chase their rent every month. They just want you to vacate and get somebody in there that will pay the rent. So we're going to continue this. I was very busy that morning of the 29th of July, 11:30.
Well, what I was going to say is I would have everything and all the rent, back rent and current rent paid by September 12th. That's with my grandson's paychecks coming in and my checks every 2 weeks.
All right, well, he can agree to that, or she can, but she doesn't have to. So we're gonna address this again July 29th at 11:30. And if they stand on their rights to terminate your tenancy, you would get 10 days from July 29th to vacate, or you'd be subject to being evicted, which would be August 8th. If you can work out an agreement whether you pay money and you get to stay there, that's up to them. But what they represented is they don't wish to continue the tenancy, they wish to terminate it. So my advice is you hold on to your money to put a first month's down on the next place, and then you start looking for a place to go. I'm adjourning this for 15 days because I'm going on a trip. And then you're gonna have 10 days after that. So you have 25 days to try to find a place to move to. Or work out some sort of agreement.
Well, I thought we had an agreement when I spoke to Mr. Santana yesterday, wasn't it?
Well, he put on the record what the deal is, and he doesn't own the property, she does.
I've never dealt with his wife. It's always been him.
All right, well, he could be like the property manager, I guess.
But they can pick up $950 today or tomorrow, whichever.
All right, well, that's up to them. Miss Yesenia Sanchez Ramos, did you understand everything I said here?
Yes, sir.
I wish you guys would get a lease. It protects you and the tenant. It makes things easier for everybody, but right now, Mr. and Mrs. Worthington, you've got a lawful notice to quit. They waited 30 days and filed the lawsuit. I set this for a hearing. They're not asking for money, they're asking you to move. If they accept money, that's up to them. If they choose not to accept it, that's up to them too. And if they don't, on July 29th, I'm gonna give you 10 days to vacate.
July 29th at what time?
That would be at 11:30 a.m.
Okay, is it
All right.
Zoom again?
Yes, it will be. You'll get a new notice, but you did a good job of zooming in a timely manner.
It took
All
me
right.
a minute, but
All right, you did better than a lot of people do. All right, I see you on that date. All right,
Thank you.
thank you.
Have a
All
good
right,
trip,
it's
Judge.
It's 11:59. We finished our morning docket. I have a very unpleasant preliminary examination at 1. And then we'll take care of that. But I guess we crammed 7 pounds into a 5-pound bag this morning. And now I gotta make sure my notes are all accurate. Thank you. I'll see you on the 29th.
Thank you, Judge.
Thank you. I'll stop the live stream and I'll see everybody else on the 29th.